Hello and welcome to Bite Size Law. I'm Amanda and I'm a private tutor in property law. This is the third lecture in a series of lectures on unregistered title and third-party interests. So in this lecture, I'm going to be looking at the Doctrine of Notice. And here's just a reminder about how it all fits together. We're dealing with equitable interests which can't be registered as a land charge. So the Doctrine of Notice will apply to interests arising under a trust of land. They are covered by the Doctrine of Notice. And any other rights which have been developed by the courts after the land charges legislation was introduced back in 1925. So equitable rights arising under proprietary estoppel will also be dealt with under the Doctrine of Notice. And then you also have the existing equitable rights, so pre-1925 restrictive covenants and equitable easements. So a new owner of the land will be bound by these pre-existing third-party rights unless they can show that they fall within the definition of what is known as equities darling, a bona fide purchaser for value of a legal estate without notice. And you will come across equities darling again when you study equity and trusts. So if you are a bona fide purchaser for value of the legal estate without notice, then you won't be bound by the third party interest. So here's a simple example. Meet Penny the purchaser, and she has just bought a new house. She bought it from Victoria, who was the vendor, who had lived there for many years with her boyfriend Boris. And Victoria and Boris recently split up. Boris moved out of the property, and that's why Victoria was selling. But when Victoria bought the house, Boris paid £10,000 towards the purchase price, which gave him an equitable interest in the property. So Victoria was the legal owner, and her name will be on the title deeds, but the beneficial owners were Victoria and Boris. Boris's equitable right can't be registered as a land charge, so we have to deal with it under the Doctrine of Notice. So Penny the purchaser won't be bound if she bought a legal estate and she acted honestly and in good faith and didn't know about Boris's equitable interest before she purchased the property. So let's break it down into bite-sized pieces. And first of all, the purchaser must be bona fide. So bona fide means in good faith. Or if we take the definition from Midland Bank and Green, the purchaser must be genuine and honest. And as we'll see, this is linked to the issue of notice, because a purchaser who is corrupt will almost certainly be aware of the rights that he's trying to defeat. The next part is a purchaser for value. Now, the first thing to note is that a purchaser includes a mortgagee. If somebody takes a mortgage or a charge over property by way of a mortgage, then the lender is a purchaser. And that's why you'll very often see that one of the litigants in litigation in this area might be a bank or a building society. And in land law, the word purchaser is used in another unusual way, in that it refers to anyone who has become an owner of the land, whether or not they actually gave any value for it. So, for example, if someone inherits land, they are deemed to be a purchaser of the land. However, by adding the words for value means that the purchaser has to provide valuable consideration in order to be equities darling. And note that it must be something more than nominal, but it doesn't have to be adequate consideration. So in the case of Midland Bank and Green, a payment of £500 to buy a farm which was worth 100 times that amount was still treated as valuable consideration. So the purchaser was a purchaser for value. So something to watch out for in an assessment is if the property is sold for considerably less than it's worth, the examiner wants you to consider whether that is going to prevent the purchaser from being a purchaser for value. And if you rely on the case of Midland Bank and Green, the answer to that question is no. There just has to be some consideration. So who isn't a purchaser for value then? Well, if you are lucky enough to receive land as a gift or to inherit it, then you're not a purchaser for value. The next element within the definition is that the new owner must buy a legal estate in land, and there are only two legal estates which can exist, which are fee simple absolute in possession, so a freehold, or a term of years absolute, which is a leasehold, a lease. So the purchaser of an equitable estate can't claim that they are equity's darling. And now we come to the big one, which is notice. And most assessment questions will require you to consider this in some shape or form. A notice simply means whether the purchaser knew about the third party's interest. So how do you work out whether a purchaser had notice or not? Well, there are three different ways in which somebody can acquire notice. They could actually know about the third party right, or that the purchaser should have known, or that notice can be imputed from the knowledge of their solicitor or other agent acting on their behalf. And we refer to them as actual notice, constructive notice, or imputed notice. And we have a statutory definition in section 199 of the Law of Property Act 1925. So now let's have a look at that statutory provision. So if we break it down into bite-sized pieces, if we look at subsection A, you'll see that first of all it refers to something which is within his own knowledge. So we're talking about a purchaser here. So something which is within their own knowledge, so that would be actual notice, or something which would have come to his knowledge if such inquiries and inspections had been made as ought reasonably to have been made by him. And this is the statutory definition of constructive notice. In other words, what a purchaser would have known if they had carried out proper inquiries. So as a purchaser, you can't just decide not to make any inquiries to avoid finding out something which might adversely affect the land. Or if you do discover something, you must make reasonable further inquiries to find out what it is. So just to repeat that important point, you will be deemed to have notice of what you would have discovered if you had carried out proper inquiries, whether you actually made them or not. So the issue then becomes, well, how far do you have to go? The statute uses the word reasonably, so you have to take reasonable steps to find out if there are any equitable rights which adversely affect the land. So now let's have a look to see what that would entail. And there are two parts to this. So in order to avoid having constructive notice of something, the purchaser must inspect the title deeds of the property and inspect the land itself. So let's look at those in turn. First of all, inspecting the title deeds. So you'll have a bundle of documents which you need to go through. And of course, the main reason that as a purchaser you're going to insist on seeing the title deeds is to check to see that the seller is in fact the owner. So you'll want to see a chain of documents showing the change of legal ownership ending with the current owner, who is the seller. So how far back do you have to go in looking through these documents? Well, previously you were expected to go back at least 60 years, but this has now been reduced to 15 years. So you're looking to start with a document which deals with the whole of the current legal and equitable estate, which is at least 15 years old. And once you've found that document, which is at least 15 years old, you're then looking for a chain of documents up to the current owners. And the starting document is referred to as the root of title. But for our purposes, the important point to note is that you will have constructive notice of anything revealed in those deeds. So, for example, it was common for owners of equitable rights to insist that a note of their interest was written on the back of the deed of conveyance to the then owner, or the deed itself might describe the third-party right within the deed, so it might recite the existence of an interest. So you'll have constructive notice if you fail to carry out a proper inspection of the title deeds which would have revealed the existence of an interest. And the other part to constructive notice is that you must inspect the land. So you're looking for anything physical on the land which might suggest that a third party has an interest over that land. Now, if an inspection would have revealed that somebody was in possession of the land who wasn't a legal owner, then you're deemed to have notice of that person's rights in the land. And this is known as the rule in Hunt and Luck. So a purchaser runs the risk of having constructive notice of the rights of anybody who is occupying the land, so they must ensure that they make proper enquiries about them. And this includes the vendor's spouse. You can't just assume that he or she is living there just because they're the wife and husband of the seller. They could have a beneficial interest in the property, so you need to make inquiries in relation to that. And if you don't ask, you will have constructive notice of anything that your inquiries would have revealed. And a good case to read is Kingsnorth Finance and Tizard. And here the house was in Mr. Tizard's sole name, and he remortgaged it to the Kingsnorth Finance Company, raised money which he mortgaged against the property, and then unfortunately disappeared with the money. And the case is an interesting one because it tells us what the court expected on the facts of that case as reasonable enquiries. And what happened was an agent of Kingsnorth Finance arranged directly with Mr. Tizard that he would go and inspect the property on a Sunday afternoon. So it was a pre-arranged inspection. During the course of discussions, Mr. Tizard revealed that he was married and him and his wife were separated and his wife was living nearby. And unfortunately, the agent failed to report this back to their principal. And another fact was known by Kingsnorth Finance, which was that when Mr. Tizard had filled in his application form for the loan, he described himself as being single. But then, of course, it's later revealed that he was married. So once it was apparent that there was a spouse in existence, the court said that the purchasers, Kingsnorth Finance, should have made inquiries to see whether Mrs. Tizard had any interest in the property. So a pre-arranged appointment with him on its own wasn't sufficient. The court said that they didn't expect the agent to look through the wardrobes and in the cupboards. There were, in fact, some of Mrs. Tizard's possessions left at the property. She used to pop back now and again to help with the children and so forth. But it was the fact that the agent became aware that Mr. Tizard wasn't single, that he was married and there was a spouse living nearby, and that information should have been acted upon. So this is bad news for the finance company. It was bound by Mrs. Tizard's equitable right. So when the house was sold, the finance company had to share the sale proceeds with her, and their share wasn't enough in order to clear Mr. Tizard's loan with them. And then finally we have imputed notice, and there's the definition there on the slide. So essentially imputed notice is that you are deemed to know what your solicitor, barrister or any other person acting on your behalf knows about the land. So what type of knowledge can be imputed? Well, if we break down section 199(1)(b), first of all, it refers to things that the solicitor or agent actually knew about. So their actual notice is imputed to you, the purchaser. But on the next slide, we'll see that constructive notice can also be imputed as well. So you're imputed with constructive notice of anything that would have come to your solicitors or agents' notice if they had carried out the correct and proper enquiries. So if we go back to Mrs. Tizard, remember that Mr. Tizard had arranged for the bank's agent to go round and inspect at a prearranged time, and during the course of a conversation between Mr. Tizard and the purchaser's agent, the agent discovered that Mr. Tizard was married. And the court said that that was a significant factual finding which should have been reported to his principal. So his knowledge that there was a wife was imputed to the purchasers, to King's North Finance. And once that knowledge was imputed to King's North Finance, they should then have made further enquiries, particularly because they had actual notice that Mr. Tizard had described himself as single on the loan application form. So let's go back to Penny, our purchaser, and we can now be more precise. We need to see whether she's given consideration for the purchase of a legal estate, whether she acted honestly and in good faith, and whether she had any actual constructive or imputed notice of Boris's interests. Well, we can assume that she gave valuable consideration and that she purchased the legal estate of the property, and also that she acted honestly and in good faith. She had no actual knowledge of Boris's interest, and there won't be anything in the title deeds about Boris's interest, so she won't have constructive notice from the title deeds. And also, if you remember, Boris had moved out of the property at the time when Penny purchased it. So as long as there was nothing on the property which suggested that Boris had been living there, so if he'd taken all his possessions with him, then she won't have constructive notice of Boris's interest. And assuming that her solicitor or other agents know nothing either, she won't have imputed notice. So essentially there'd be nothing to put her on notice that someone else might have an interest in the property, which is good news for Penny because it means that she's not bound by Boris's equitable interest in the property. If you find my examples helpful, and remember that I will be going through some more in the final video in this series, please add comments in the box below. I do find them helpful. I can't answer individual questions which don't relate to the video content, so if you ask me questions about your own individual assessment, this isn't really an appropriate forum for me to respond, but if you have any general feedback, I really would be delighted to hear from you. Hopefully now that you've looked at the doctrine of notice and you've also watched the video on land charges, you can appreciate why the system of land charges was introduced, as the inquiries a purchaser would have to make without the land charges system can be very time consuming and very complicated. So to sum up, the position that we've reached at this point is that a purchaser of land, if they don't want to be bound by equitable third-party rights, must carry out a land charges search against the names of the landowners to see if there are any land charges registered against the property. They must check the deeds to the property going back to the root of title, which has to be at least 15 years old and onwards, and they must also inspect the land and investigate any occupiers of the land who are not the legal owners. So thank you so much for watching. Please consider subscribing or liking and sharing my videos, as it really does make a difference. I am a private property law tutor, so if you're interested in private tuition, please feel free to contact me. My email is there for you and in my details on my YouTube page. So thanks again for watching and good luck with your studies.